In the framework of International Network of Judicial Reformers, we continue our series of the discussions, of course, despite this tough situation in which Georgia has to operate. Today, as I mentioned, the draft law of transparency of the foreign influence was adopted by the Parliament in the third reading, and today on the Committee of Legal Affairs was overcome the veto of President. Tomorrow, the same held in the plenary session of the Parliament. We have, of course, huge demonstrations outside every day, but still the network continues to work on the main core issues for the future of Georgia and for this European future of Georgia, and independent and accountable judiciary, of course. And with support of USAID Georgia independent program, today, we have this great opportunity to share the experience of Slovakia and US about the rule of law backsliding. Of course, I welcome our excellent speakers, Peter Kouros and Jim Moliterno, who will give us their insights and expectations about the current situation and event. Before I will pass the floor to our moderator, Ekaterina Tsimakuridze, who is the head of Democracy Index Georgia, and also member of Group of Independent Lawyers and International Network of Judicial Reformers. I will just pay your attention about technical details. A discussion will last 1 hour and 30 minutes, and it will be translated and recorded. Please find this law for Georgian. You must choose who speaking English language, and you must choose Georgian who wants to hear Georgian translation. So we can begin, and the floor Eka, and ask her to lead the discussion.
Yeah. Thank you, Kata. Thank you, everyone, for participating today in this discussion. Good to see our dear speakers and other guests who are, I'm sure, joining the protest, and it's even more valuable that they are still participate in this discussion, and actually very important topic, which is very much related to processes in Georgia as well as in Slovakia. I will start with introducing our speakers. They are very active in our network, and most of you might know them, but again, it's important to mention their experience and the work they do in the field of the judiciary reform. Kouros, postdoctoral fellow in the University of Oslo. He has extensively worked on the formal selection of constitutional court judges. He was engaged under the name Judges Under Stress, which is a very important direction in the judiciary reforms, and many other works he has done in the field of judiciary. Mr. Jim Moliterno, of course, I think I will not be able to list all of his work and dedication to the judiciary profession and judicial reforms. But I should mention that Peter and Jim has worked together, cooperated on different issues, including the topic related to the independence of judiciary. So I think it's going to be very interesting to listen to you speaking today on this matter. I just very briefly say that today's topic is, of course, inspired with the ongoing and the law that has been adopted regarding the foreign transparency of foreign influence. Very often they tell us that this law is to United States FARA law or other democratic other laws that are similar laws that are in democratic countries. But we should again and again mention the major difference, I guess, which usually ruling party is overlooking and trying to persuade public that these laws are very similar to democratic ones. That in Georgian law, which is very similar to Russian law, it would apply to extremely large number of non-governmental organizations and the media who will be labeled as agents of foreign influence, while of course they are not agents of foreign influence. But for example, in democratic countries, under this type of law would fall the organizations or individuals who act on behalf of a foreign country. This is a significant and major difference, which makes Georgian civil society completely puts under this law, and the only outcome this law might have in practice is that sooner or later we all gonna stop our operation. It's gonna be impossible for us to continue our efforts, which we have in so many different areas, whether it's judicial independence, anti-corruption, fair and free elections, and etc. Today we and our speakers also suggested that the topic could be put even in a broader perspective, because this is not a the matter of single law, but it is really related to something bigger, this is why to discuss from the perspective also of Slovakia, which is considering the similar law also right now, and to see the matter from a broader perspective, I think will help us better oppose to this situation. Thank you so much. I won't continue more, and we'll ask maybe Jim to start, and then Peter will follow. Thank you.
I think the plan is for Peter to go first between the two of us. Is that right, Peter?
Yes,
okay.
I'm fine, but I'm fine with both scenarios.
No, it's okay. It's okay. You should go first as we planned, Peter. And my only question is, will we be able to share screens? Do we have that power? Making us hosts or co-hosts or something.
You should be able to share screen. Okay. Let's try, and we will help.
Pekka, could you also allow me to share?
Yeah, Peter needs to be able to also.
Okay.
Peter, there is a button share screening.
Yes, but
it's not working.
No, when we press it, it says host disabled participant screen sharing.
1 minute, I will just ask our technical support.
Yeah, thanks.
I don't have host function here, so
okay.
Host will do it.
Yes, the host can help us with this. Have slideshow or something, right?
Yes, a very extended presentation.
Yeah, okay.
So maybe I can start without the presentation and hopefully we will be able to.
Yes, please. I think that's better.
Yeah, and maybe is there another link that I should have tried?
Another link? No.
No, this is the only one. Okay. So, my presentation and my talk today, I have to start my stopwatch first because usually my problem is that I go over my time and I talk too much. So please, in case I forget about it, do not hesitate to stop me, especially you, Jim, because I will take more of your time. So you are all allowed to stop me at some point. So I called my presentation the signature scent of the rule of law backsliding. As you know, for example, in perfumes or in case of beard oils, there is always by the brand some signature scent that the brand is famous for. And I called it because, well, we can detect this signature scent of the particular rule of law backsliding in every country. And today we will focus on the resemblances of the case in Georgia and in Slovakia. And I'm very happy that I see so many people in the audience here. Thank you very much that you found the time to join us. So not only the resemblances, but really the particular examples of the backsliding, how it is happening. Is the present screen already working? No. So not only the resemblances, but also the examples. And usually this topic slides mainly into the topic of the independence of the judiciary. The judiciary is, of course, one of the main problems when the authoritarian and populist governments are taking the steps towards more populist politics. But it's not the only one. There are also other pillars that are affected. And one of them might be the legislation process. The legislative power and the executive power may have the ambition to create some kind of the state of exception. We know many varieties of the state of exception. Usually in the constitutions, they are reflected as states of emergency. For example, in Central and Eastern European countries, there are several levels where and each level allows more and more exceptionary powers to the legislator and to the government. And but there are also the ways how to create an exception inside the rule of law. So the legislative process still looks like it is happening within the frames of the rule of law, but basically it is bending the rules, creating exceptions, using the space provided for occasional exceptions in the legislation for every possible example that they might need. So for every occasion that the power would need to pass some law very quickly, and there are not the real conditions that should be. It is working. Okay, can you see?
Yes, we can see now, Peter.
Yes, but yeah. I think it's not extended.
Okay.
To the. I'll just open it and all right. And now I'm sharing the screen. Is it okay now? Yes?
Yes, we can perfectly see.
Yeah.
Great, amazing. So, the third would be the third way of creating some situation of the backsliding would be disqualifying the associate the right of the common interest pursued by the civil society organizations. And this is exactly what we are talking these days in Slovakia and in Georgia. In Georgia, even more actual. The topic is, as you are facing already, the presidential veto and the law coming back to the parliament. Now let's explain the situation in Slovakia. So in between 2020 and 2023, there were two governments, basically of the same political parties. The only change why we are talking about two governments is there was a change in the position of the prime minister. So on the left, we can see Eduard Heger. On the right, we can see Igor Matovic as the two prime ministers in this period between 2020 and 2023. In September 2023, the administration, Robert Fico has been before. He was the prime minister for 3 times, and this is his 4th. I assume that everybody already heard about the assassination attempt that happened 2 weeks ago, or less than 2 weeks ago. So after this terrible thing that happened, the attempt to assassinate the prime minister is stabilized. He is according to the doctors, he is in a good condition in the hospital. But outside, what is happening is that the backsliding and the steps of the government towards the civil society, towards the independent public broadcaster, are accelerating. So after the assassination attempt, there was a short period when it seemed that there might be some way of reconciliation of the very polarized society, but at the end was... Sorry?
Somebody has a microphone. I think it's okay now. Yeah,
it's okay.
But it quickly developed into the situation that the ruling coalition parties refused to do any reconciliation after the attempt to assassinate the PM, and they just followed with accelerated pace. So let's take the first pillar, the threats to independence of the judiciary. We have seen in this region, like 3 neighboring countries, Poland, Hungary, and Slovakia, we have seen the attacks in the reforms that reminded the attacks to the independent judiciary already in Hungary since 2010. There was adopted new constitution. There were adopted limitations on the constitutional court, such, for example, the barrier of the constitutional court to refer back to the case law from before 2012, for example. There were the changes at the Supreme Court that even changed the structure and the name from the Supreme Court to Curia. There were the changes in ordinary courts, mainly done by the retirement age of the judges. And there were changes in administration, like creating executive body of the court administration, the National Office for Judiciary, that was very politicized. There was a political representative elected by the parliament standing or sitting in this office. The other scenario happened in Poland. It was very similar, but because the party Law and Justice, Prawo i Sprawiedliwość, did not have the constitutional majority, they had to apply different steps, but they wanted basically get to the same target, to the same. They had the same ambition, so they had to take control over constitutional tribunal. They had to take control over administration of justice. So they changed the way how the members of the Judicial Council are appointed and who appoints them. So they basically changed the body that appointed the majority of the judges from the peers, judicial peers who elected judges. The same, the lower chamber of the parliament was electing judges instead. So it was very politicized again. The part of the reform happened to be in the Supreme Court, again, creating new chambers. Most discussed the disciplinary chamber and extraordinary chamber, and the reforms in the ordinary courts, again, the same ways as in Hungary, mainly through the replacement of the court presidents and lowering the pension, the age of retirement of the judges. And I don't know how familiar you are with the Slovak context, but some kind and quite extensive kind of reform happened already in 2020. But it was not that much discussed because there were not that many objections from the European Commission. The reform also happened at the Constitutional Court because there was introduced a new system of election. But again, it was very much taken into account with the principle of proportionality, because this system of appointing judges was proposed for the year, I think the earliest year when the new system will be applied will be 2031. And this happened in 2020. So they really thought about implementing these new policies without any interference into independence of the courts. There were the changes in administration of the courts. There was created the new Supreme Administrative Court, and there was introduced a very controversial institute into functional immunity of the judges. And this is probably one of two things that European Commission had really problem with. So there was introduced the crime of bending of the law. The judge could be charged with this crime if intentionally deciding against the law, against the opinion of the higher court. So this was very much controversial. It is controversial until nowadays because it is still valid law. In every rule of law report from the European Commission, this objection appears. And there is another objection from the European Commission, and it is the revoking or discharging the members of the Judicial Council. So this refers to the administration of the court. The members are elected or elected by the government, by the president. Altogether, 9 of the members out of other 9 are elected by the. So the 9 members from the political powers can be replaced at any moment, and even without giving a reason, according to the law that was adopted in 2020. This was a huge objection from the European Commission. But the previous government that adopted this law have never used it. The first government who used it was the government now that was elected after September 2023. And they already replaced 5 members of the Judicial Council. So it is possible, it's not illegal step, but it's hugely controversial because especially these parties were complaining at the Constitutional Court about this instrument. And once they came to power, they started to use it for their purpose. So 5 members, 3 of them elected by the government and 2 of them elected by the National Council were replaced already. One of the representatives of the National Council stepped down voluntarily. Then very controversial step of the Fico 4 government was the removal of the chairman of the Council for the Judiciary. It is a very interesting situation in this way because the removal happened to be quite easy. The chairman was elected from the members of the Judicial Council that were elected by the National Council. So despite this person, Jan Mazak, the former president, the former chairman, was general advocate by the European Court. He was the president of the Constitutional Court of Slovakia in the past. Despite that, he was not elected by the judges because he is not a judge, but he was elected by the National Council. And it would be very controversial by the National Council if they replaced the president. So this would be definitely in the rule of law report immediately, but as a rule of law report comes out only in July every year, so it would be in July. But what happened in the Judicial Council, they happened to be very fortunate in this way, like ironically fortunate alliance between the judges and the representatives of the government that found the same voice and decided to remove the chairman. And the next day he was removed completely. The next week he was removed completely from the Council for the Judiciary as a member by the National Council who originally elected him. There are other examples of like these small examples of the attacks when, for example, the representative of the executive power, in this case the Minister of Interior, verbally threatened the judge of the municipal court in Bratislava and the Supreme Court judges also in Bratislava because of the their decision making. So to both of them, based on the outcomes of their decision making, the Minister of Interior sent them the verbal message that he will initiate the disciplinary proceeding because he didn't think that their decision making is legitimate. There are also the threats for dismissal against the president of the Constitutional Court, and this directly from the Prime Minister after the very controversial bill on the penal code that we will come to later in this presentation. The Constitutional Court held the effectivity, like they decided, the Constitutional Court decided that the effectivity, that the law does not come into effectivity until further decision of the court, what we are still awaiting now. Immediately after this announcement, the Prime Minister threatened the President of the Constitutional Court with dismissal. So it's not such a power in the hands of the Prime Minister. And probably out of these, the last example, ministerial lustrations at the apex courts. So this is also very controversial. it happened several weeks ago. The minister, with few other representatives of the ministry, entered the Supreme Court and the specialized criminal court and asked for the whole database of the cases since 2004. For these 20 years of cases that were not anonymized, couldn't be provided, and despite of that, the ministry was requiring this database. The reason was to control whether the cases are distributed in according to law. So, but this again, is this the requirement that is proportional to the thing that they are looking for? So the outcome was different in both courts. While at Supreme Court, the Supreme Court refused. At the specialized criminal court that is mostly focused on corruption cases, the president decided to give the whole database to the ministry. What are the specialized criminal court? What already happened some few days ago, the court president, Jan Hrubala, stepped down as a court president, according to what he said, the political pressure. There were, I expect another changes at the Supreme Administrative Court, as the court that was quite recently established. I expect there will be the changes in the system of the disciplinary procedures, for which now the Supreme Administrative Court responsible, and probably it will be limited in this disciplinary procedures, and maybe these disciplinary procedures will be removed and transferred to another court, for example, Judicial Council or the Supreme Court. And also, I await some steps against the Constitutional Court, as there is an empty seat that has not been filled for quite some time, already 10 months. Also announced the court packing, so raising the number of the constitutional judges. Usually, this step is done for taking the body, the judicial body, in favor of some opinion. So, for example, with the ability to appoint the new majority of the judges, it might create the favoring conditions for particular political opinions. Why also I do not think these steps will be perceived as attacks, as it was in Hungary and Poland, when the Polish judges, for example, were very outspoken about being attacked from legislator and from executive power. In Slovakia, I don't really think, because in order to have an attack, you first have to have the resistance. Once there is no resistance, and there is some kind of political alliance between judicial association and political power, there is no need to attack the judiciary. And this is the topic of our ongoing research also, of looking into these political alliances of judicial associations and political power. There happen to be also other steps in the police force, for example, removing president and vice president, very controversially, usually by humiliating practices like sending the president of the police force of Slovakia to a small village at the other end of the country for several days, because the president expected and already asked for retirement. There were steps against the investigators of NACA, which is a national criminal agency, investigating the most serious crimes. These investigators, at least some of them, due to their nature of their job, investigating the corruption, were protected as whistleblowers in order not to be fired at some point and to finish their investigations. So the new government and the Minister of Interior, as a first steps he did in his office, was that he removed or wanted to remove this special protection of whistleblowers. In some cases, he was successful. In some cases, he was not. This is the reason. The reason is the courts deciding upon all these cases do not have the same opinion on the Minister of Interior. Now let's go to the second pillar. The second pillar is called the steps against the independent institutions. So mostly we will focus about abolishing the special prosecutor's office and politicizing appointment of the public institution. Similarly, like in Hungary and Poland, there are the interferences into public broadcaster, mainly trying to get the political control over public broadcaster. In Slovakia, through the bill that is right now in the parliament, it passed the first reading some days ago, a month ago. In the bill is proposing creating the new council, the new board council, with most of the members appointed by the minister. So it transfers the public broadcaster directly under the political control. There will be the new process of election of the director. And there will be also, at some point, there was also the requirement of removing the opportunity or the option to remove the director without a reason. One of the main and most discussed things in Slovakia was abolishing the Special Prosecution Office. The Special Prosecution Office was focused on the most serious crimes, on the crimes connected to the EU funds, embezzlement of the EU funds, and very serious economic criminality. This happened in March. It was the Special Prosecution Office was abolished, and there was still a question: what will happen with the cases and the prosecutors? And for some time, there was a guarantee that the cases and the prosecutors will not be separated from each other. But this changed very quickly after the Special Prosecution Office ceased to exist, and the cases were reallocated to different departments. So in most of the cases, most of the serious at that time, now they face the barrier. Like the new prosecutors that have never seen the files or now have to get now they have to learn everything about the files, not to miss any deadlines that are set in those cases, what will be very difficult, and we are already facing the problems and chaos. Mostly in this type of attacks, the independent institutions in healthcare, in statistical office, for example, or the secret service are also very often attacked. There was also requirements and the proposal from the government to change the law on whistleblower protection office with creating a situation that would cause the retroactivity of the law by removing the protection that was already awarded to the members of the police force would completely change the legal situation of these protected persons. The same thing of the interferences happens also in the culture, and the Ministry of Culture is also taking political control over the independent funds focused on arts. Well, usually this is happening by creating a new board, the new council that has the majority appointed by the minister. So once this majority is appointed, the minister has the political control over the body, over the institution. The court packing we already mentioned, and probably now it is also once I think the last 7 minutes, we can get to the limiting of the civil society organizations. So there happened to be several proposals by the government. The first was the removal of the assignation of the tax. Then there was the law on foreign agents or organizations with the foreign support. Often now there are used strategic lawsuits against the public participation. And what we were witnessing several days ago were the steps against or towards the politicization of this state funding or the public funding for the civil society organizations. So late in 2023, the Ministry of Labor proposed the removal of the institute of the 2% of the assignation of the tax, both of the natural persons and legal persons. This was it was one of the first steps. It was not successful. At the end, the 2% assignation still exists until now. But what it created a discourse on categorizing the civil society organization between worthy and unworthy. So this started the whole thing that led to the law on organizations with foreign support. The law right now in the government, in the parliament that passed the first reading is very harsh. It is one of those that remind more the Russian law than the United States FARA law, despite often being argued by the government that the same law exists in the United States. However, this bill resembles more the Russian version. It says that any civil society organization that would have more than €5 per year from the any person, natural or legal, from abroad, registered or with the residence abroad, will be labeled as a organization with the foreign support. This will have to be also registered in the National Register of the Civil Society Organizations. It will have to be mentioned in the final report of the organization at the end of the year. It will, and in case that the organization will not fulfill this duty, the ministry will have the power to dissolve the organization without any step of the court or without any court proceeding. It will be up to ministry, what is very dangerous in this case. But I think you are all aware and very familiar with such a danger. As I already mentioned, there was a political control of the public funding. Again, the funding that is awarded from the ministries used for some since it was established, and by the fun fact might be that it was established by the previous Fico government in the shape that it was kind of quite independent, that the majority of the councils and committees were from the civil society. Now, all these schemes at the ministries that provided public funding will be changed into the committees with having majority representatives inside them. The last is the deterioration of the participative legislation process. So, as I already said in the beginning, creating kind of exception. In Slovakia, the problem is that this started mainly in pandemic. During the COVID pandemic, it started to be more and more often used way of adopting laws, but it had the objective reasons. However, we have never seen before so many bills being passed through the fast track procedure. In the fast track procedure, it is basically possible to adopt the law in 1 week or in one parliamentary meeting. If it is physically possible for the members of the parliament, in the fast track procedure, it is also legally possible. But despite having this opportunity in the law, it should be limited by the conditions, and the conditions are set by the law that there is an imminent danger to the fundamental rights, or there is a danger of the huge financial loss for the state. But at the end of the day, we found out that finding the reasons for the fast track procedure is very easy for the government when proposing a bill in the parliament. So it is used very often since. The same way in the fast happened to be true for the criminal code, the penal code that was adopted in February, but thanks to the Constitutional Court, the effectivity of the law was withheld. And right now, except of the chaos that was created by all the new laws that were passed in the same group of the laws that were adopted in February, well, we are still waiting for the result from the Constitutional Court. The same thing applies for the changes in the Construction and Spatial Planning Act that very much interfered into ownership rights, and most of these cases will probably follow to the Constitutional Court and then to European Court. And probably another way how the executive power is able to bypass the due legislative process was the example of bypassing the president's decision on the chief of the Secret Service. On the left, we can see half of the face of the previous president of the police force, Tibor Gašpar, whom the president decided not to appoint to the seat of the chief of the Secret Service because he is under criminal charges. And as a replacement, the ruling coalition found his son. But as the president refused to appoint also his son, the government managed to change the statutes of the Secret Service. That is confidential. So the public does not know what is in the statute, but according to this confidential statute, the new deputy of the chief is the son of Tibor Gašpar. Another way how to create an exception is to change the law and to bypass the institutions that were foreseen by the law to a point. I think I'm ran out of time, and Jim, thank you very much for being so patient.
It's okay.
And, I'm looking forward to all the questions at the end.
Yes, thank you, Peter. I already saw some similarities, but from my side, just to add maybe one more thing that is happening in Georgia right now, it's we observe the abolishment of qualified majority rule in parliament and in different independent bodies, so that the opposition is not involved in the decision-making process properly. That could also be regarded as added to the list of this. What you mentioned, it's good to see the overall picture. How can the democratic process be deteriorated? And I guess in the EU and in democratic countries, it should be already so that everybody can recognize these signs and red lines. Okay, let's move to Jim, who will be talking about those similarities which I already mentioned.
Thank you, Eka. And thanks, Peter. I always learn something new when Peter speaks, so I really appreciate it. And I had been following activities in Slovakia the best I can, but of course, I just learned 1,000 more things that I was able to read about and find about. So thanks a lot, Peter. So first of all, I want to say Georgia and Slovakia are sort of my places. Number one, Georgia. I started working in Georgia all the way back in 2006. A lot of it was with lawyer ethics, but it was has been over these years, 18 years, a very wide range of activities, including a lot of activity with this group, as many of you know. But number two is Slovakia, and I started working there in 2012. I think that's about when we met, right, Peter? 2012 or 13. And I've had a range of activities there, including very direct, as I'll tell you the story today, very direct engagement in judicial reform activities in Slovakia. Some of them had some success, some of them not. But I will tell you that story a bit today. But these are my two places away from my own home that are my kind of most important places. Of all the 15, 16 countries where I have worked, these are the two that hit my heart the deepest. Both countries, as we know, are in turmoil right now. And this is a photo, as many of you recognize, of Tbilisi from not more than a few days ago, really. And I see so many names on the list of people who are attending right now. And because I don't see photos of you, I guess maybe you are in the protests right now. You are on the streets, even as we're speaking. I don't know. But both countries are in turmoil over the foreign agents law, over, as Peter told us, Prime Minister Fico's assassination attempt, and all of the intense government attacks on reformers in Slovakia that we just heard about from Peter, in the media, in anti-corruption bodies, in the Judicial Council, and so forth. So here are two of my favorite places, and it presses on my heart when I see the things happening. But what I want to do today, even though we are all kind of captured a little bit, as we should be, by the very important present affairs, I want to look back and follow the story of the judiciary in Slovakia from about 2000 on, so more than 20 years, almost 25 years in the Slovak judiciary, and see what we can learn from stories. I very much believe that telling a good story can reveal comparisons, differences. It can suggest strategies. It can channel our efforts. It can do many, many things if we follow a story closely enough. And we will see in this overarching period of time, back in 2000, that the stage was being set for deep, well-organized judicial corruption that may have existed even before, of course, but the stage was well set for well-organized judicial corruption. We'll hear about, I hope, I'll tell you, a period of some improvement and some hope. But now, as we've heard from Peter, and I'll reinforce that, we're seeing the backsliding in the judicial setting, especially in the judicial pillar that he talked about in 2023 and 2024. So every story needs a main character. And the main character of the story I'm about to tell is this man, Stefan Harbin. He, it depends on your perspective, but you may want to call him the villain. If you have a good story to tell, you often need a villain, right? And so he will be a main character in this story for sure. And he will go along, at least in the story I'm telling, from the very beginning to today. Early in his career, he graduated from the law faculty in Košice, which is Peter's law faculty. So I don't know if you want to say hooray for Stefan Harbin being from your law faculty, or maybe something else. But that is his home area, I believe. And by 1983, he was already a judge in local and regional courts in that part of the country. It's the eastern part of Slovakia. And by 1991, he had already achieved a seat on the Slovak Supreme Court. So all of this is a little bit before the starting time of my real story, but I have to tell you a little background about Mr. Harbin. He rose to president of the Supreme Court and served in that capacity the first time from 1998 till 2003. And he was the chair of the first judicial council starting in 2001 in Slovakia. So why did there become a judicial council in Slovakia in 2001? It was part of the accession process, part of the process of negotiating with Europe to become a member eventually of the EU. And one of, as we know very well, one of the features of the often negotiation process, something that exists in Poland, exists in Hungary, exists in Slovakia, and is urged and exists in aspirant countries like Ukraine, like Georgia, is the idea of having a judicial council. Why is there a judicial council? It is meant to create a higher level of independence than what existed in communist times, in former times. And it is very effective at doing that. There are risks that need to be carefully managed in creating judicial councils. And Peter and I, along with two other young colleagues in Slovakia, wrote an article about the risks of judicial councils and that they need to be created with a good balance of accountability. We wrote an article about that was published in 2018. So he became the first chair of the Judicial Council beginning in 2001. Now, he was pushed out of his judicial posts in 2002, 2003, partly based on corruption allegations, partly based on claims that he was inept. And many expected, I think, at that time, I've read some of the articles and history from that period, many expected that he would be on the what we call dust bin, the trash of history at that time, because he was pushed out of his judicial places. I've actually read documents from the U.S. Embassy from my time of working with the U.S. Embassy later that recount this history of Mr. Harriman and his being pushed out of the judiciary in that period of time. And so many thought he was over. He was finished. He would have concluded his sort of impact on affairs in Slovakia. And some useful reforms occurred during his absence from the scene between 2003 and 2006. I believe the Special Criminal Court was created, and some other investigatory anti-corruption activities took place during that time. However, new elections brought change in 2006. And what did they bring? They brought Robert Fico, the current PM, to his, I think, first government. Peter can correct me if I get some of the history wrong, and I don't mind. But I think this is his first government in 2006 to 2009. And Harriman reemerges. So Harriman becomes relevant again the first time that Robert Fico becomes prime minister. Harriman becomes Minister of Justice. So remember, he has been the Supreme Court, on the Supreme Court. He has been already the chairman of the Judicial Council, the country's Judicial Council, and now he becomes the Minister of Justice in the government from 2006 to 2009. So he is now in the government side of things. Then he switches back. And many of you in Georgia, I know we talk very often about the judiciary in Georgia at some point, sort of beginning a collaboration with the ruling party, rather than resisting and trying to maintain independence, in some ways, reaching a sort of collaboration with the ruling party. Well, Mr. Harriman was able to make that collaboration with himself. It was a very unique sort of collaboration between government control and the judiciary. How did he do this? Well, while he is still the Minister of Justice and the Deputy PM, legislation is introduced that passes significant Minister of Justice or Justice Ministry powers on to the President of the Supreme Court and the Chair of the Judicial Council, and then he returns to be the Chair of the Judicial Council and the President of the Supreme Court. So he made a deal with himself. He was essentially on both sides of the transaction that created a power structure that he himself is able to assume when he becomes again the President of the Supreme Court and Chair of the Judicial Council. From 2009 until 2014, while he is both Chair of the Judicial Council and President of the Supreme Court, what a concentration of power already that is. But it's even greater because he has transferred many ministry powers to those positions. While he is in this position, he creates a system of almost unchecked power over the judiciary. He builds a network of loyal judges in key courts and positions. And I'll say a little bit in a moment about how he did that, how he built that structure of loyal judges in key courts and positions. Now, as I'm telling the story, I have to say that this was during the period 2009 to 2014, it was about 2012, when I was first invited to Slovakia by the US Embassy with two jobs, if you will, or two packages of work to do. Number one, I was meant to help introduce the subject of legal ethics into Slovak law faculties. That's how I met Peter and a number of other wonderful, wonderful colleagues with whom I have stayed very, very close over the years. That was number one. And number two was to find a way to engage with the troubles in the judiciary centering around the topic of judicial independence. So this was my task, if I could do it. Now, back to Mr. Harabin. What were some of the techniques that he used to create this power and wield it, use it, implement it in many different ways? Well, for one thing, he gave money to the judges. He paid bonuses to the judges, some of which were meant to be paid by law and had not been paid previously. So it seems like a good thing that he's doing. But he including to himself, gave the largest ever bonus to himself. He decided how much will each judge receive in these bonuses. And because of judicial independence, he said, he refused government's routine efforts to audit the financial records of the judiciary. The government tried to examine the financial records of the judicial branch, which is an ordinary thing that happens no matter how independent the judiciary is. It is not meant to spend the government's money however the, let's say, chair of the Judicial Council or highest judge chooses to do it, right? They are not meant to have complete, unfettered freedom to simply spend the money any way they want. But he resisted this, and eventually it even turned into European Court of Justice or human rights, I guess Court of Justice cases, maybe human rights cases. Peter probably knows that. But he used this power of giving money to certain judges and not so much to others to create his own network of people who would be loyal to him. He also made very extensive use of defamation claims to silence and punish media critics. So when anyone in the media would accuse him, often truthfully, of having very close relationships with Albanian drug dealers, for example, just one example, there are videos of him at the birthday parties of children of the Albanian drug dealer having a great time, a wonderful time with the drug dealer who was at the same time in the Slovak justice system for his crimes. But when someone would when a media critic would publish something about him, he would sue them for defamation and track the litigation into the court of one of his judges, one of his loyal minions. And he won, again, Peter might know the detail of this better than I do, but more than 1 million euros in defamation claims that he won by tracking them into very friendly judges' courts. That's a way to consolidate your power and to silence critics. He very extensively used the judicial discipline system to punish honest judges who were criticizing him and trying to remain independent. Notice that the judges I'm talking about now, that after, they were not trying to remain independent of the government or state actors, you see. They were trying to remain independent of the corrupt judicial structure of, for example, their own court president or of Harabin himself. This is the independence that they sought. And this is the sort of independence that is needed for judges in systems where there's an abundance of independence, not an accountability. Judicial system. Here I want to introduce you to a group of judges that called themselves, and it's on the slide, for open judiciary. And again, I might make the translation wrong, but that's what we called them when I started working with them in about 2013, 12 or 13. They were a group of judges, like some very good judges that I know in Georgia, very good judges who wanted to do their job right, who want to do their job as they should in the public interest, who want to behave in ways that are perhaps not pleasing to the powerful judges, the leader judges who are trying to control the judiciary, right? These judges, I believe, no longer exists, but at that time they had their own organization, their own association that was called for open judiciary. They were in favor of a transparent, fair, impartial, public interested judiciary. And Haribin didn't want them in the positions anymore. He sought judicial punishments for them, ethics punishments in the judicial discipline system so intensely, think about this for a moment, that the EU ambassadors and the US ambassador began attending judicial disciplinary hearings. They personally went. They didn't send a representative. The US ambassador went physically and stood in the hearing of the judicial body against these good judges. It was that intense. All these things, however, Haribin was able to build his structure. Now, a little aside about judicial independence. I didn't know this before I went and started working in Slovakia. I didn't actually know this idea. But there can be too much judicial independence with accountability measures. When I started thinking of the Slovak context, I came to realize that the judges, especially the leading judges, Haribin and his people, thought of judicial independence as their own property. This was a sort of property right of judges, and it created a shield around them, a kind of force field, if you like science fiction better, right? That they could not be touched because of this wonderful, beautiful concept of judicial independence. Well, that's not what judicial independence is actually about. Judicial independence is about it being an instrumental concept that allows judges to decide cases impartially for the benefit of justice, for the benefit of society, without interference with their decision-making by state actors. That's what it's about. It's not meant to be property of the judges, owned by them. No. And what I found and learned as I started working more and more in Slovakia was that extreme judicial independence, if it's not balanced by reasonable accountability measures, creates the opportunity for extreme corruption inside the judiciary, inside it. It created the system, and Haribin helped create it himself, as we saw. He created the system so that there could be corruption inside the judiciary that was not seen by the outside world very easily. So to begin dismantling this condition in Slovakia, Haribin, we concluded, must have his power reduced somehow. Have his power reduced. Wow, how do we do that? The first step to doing it, I can tell you, and I have not told this story to many people before, the first step was a meeting at the US ambassador's house. And I met there with many EU ambassadors and charge d'affaires when the ambassador was unavailable. And we discussed the situation in the Slovak judiciary together. You know, this is the US sitting here, and it could only really be properly, any engagement could only be properly done with the understanding and the blessing, if you will, of EU countries that were there. So we discussed and agreed we need to do something to reform the judiciary. And Jim Moliterno, if you think you can help, go for it. That was essentially what I was told at that meeting. Wow. So what should we do? We built a plan to try to push Haribin aside if we could. There was a meeting in a hotel bar, the hotel where I was staying at the time in Bratislava. There was an embassy representative, a wonderful man who is a brilliant legal reformer. I'm not going to name the names of the other people with me in the meeting. Brilliant, wonderful legal reformer who is a dear friend today still. There was an NGO leader, a Slovak NGO leader at that time. Peter knows this Slovak NGO quite well. And a legal representative, who I also won't mention the name of that NGO, and me. We met in the bar, hands on cocktail napkins, drew up what we would do, what we will try to accomplish. It's that a small thing. It was a simple plan. We knew that there would be a next round of judicial election where peers, judges would elect a Supreme Court president and head of the Judicial Council. We planned to persuade the good judges from open judiciary to stop trying to recruit new members. Don't do it. People won't join you. If they join you, they know they are about to be charged with a disciplinary violation and their lives ruined. They're not going to join you. You will never get to be a big organization, we explained. Instead, you judges, you good judges, know other good judges. You know them. You know who they are. You know the other judges who want a better, cleaner judiciary in Slovakia. All we want you to do is have quiet, one-on-one conversations with good-hearted judges, simply asking them to vote for someone other than Haribin. That's all. When the next elections come. Simultaneously, we wanted to find a way for us to communicate with a mass of judges, as many as we could find, planting the idea that a better future could await them. Their future would be better. Their lives would be better if the judiciary was viewed by the public and non-corrupt. And we wanted to convince them that the only way to do that would be to have reputable leadership, better leadership, without mentioning, of course. The open judiciary went fine. We already knew them well. All of us did. Some of us, not the whole group, met with them. They went off to have their meetings to try to convince party judges to vote for someone other than a small thing that cannot happen on Zoom, but it did happen. the embassy was able to arrange for me to have a meeting of the Judicial Academy. Mr. I think he still is it? Is he still the head of the, yeah, okay. Mr. Hula. And I met with him in the city where the Judicial Academy is centered, Pezinok. Yes, yes. And what did I discuss with him? Reform, anti-corruption, a new judicial conduct code? No. I discussed goose dinners, young wine. There is a tradition, at least in that part of Slovakia, and again, Peter can nod or shake his head if I'm wrong, at least in that part of the country, at this particular time of year, I think it was in the fall, there is a tradition of having really lovely goose dinners and drinking the very, very, very young wine that is not matured yet. What I talked to Hula about, and we became friends. And he agreed to do something never agreed to do before, and that is allow someone, a representative of an NGO or a US embassy or another embassy, to address large groups of sitting judges. And that's what happened. The plan for those sessions from the judges was arranged by the US Embassy. I had 3 stops in 3 days. I met Peter at the end of it, at the eastern end of the country in Košice. I spoke to more than 150 nations. I think it was altogether more than 600 judges that I managed to speak to. And at that time, that was almost half the judges in all of Slovakia. I got to speak with them in those days. And what did I say to them? I praised them. I told them that I was confident from all the judges I had met in Slovakia so far, that the great majority of them are honest people as well for the public interest. I praised them. You, I have no doubt, are trying your best to have a good, honest judiciary. And I told them that their lives could be better if the public believed what I believe, that they are mostly good and honest people trying to do their job well, that they would go out to get in their car in the morning and their would look and say, ah, look, my neighbor is a judge. This is honorable. Instead of, my neighbor is a judge. He is surely corrupt. This is the life I tried to convince them that they could have someday if the judiciary would be perceived more honestly. I did this with the complete understanding that the members of For Open Judiciary were having private conversations and spreading out like a web to have private conversations with many of the same people that I was speaking with, telling them how they could have a more honest, open judiciary. What were the results of this? Well, I'm not deluded into thinking that we did everything. We did not. There were many other factors that were taking place at the same time. Haribin, in some ways, was publicly making a fool of himself at the same time. However, I believe that partially caused by our efforts, what happened in the next round of judicial elections, Haribin was not elected to be chair of the Judicial Council. In the next selection of a Supreme Court president, Haribin was not selected to be the next Supreme Court president. In the judiciary, at least, in the judiciary, he was largely sidelined for 10 years. Yes, he has life tenure, right, at that time in his Supreme Court position, so we couldn't make him stop being a judge, but we took him out, or helped. We helped. I don't want to be too bold in what I say. We helped to take him out of his position, his highest positions. During this 10-year period, he ran to be president twice, and I think Peter can nod, prime minister once. Yes. He finished third or worse in those national election efforts, and instead, he became a shrill, right-wing, crazy voice on social media. If I spoke Slovak, I would go and listen to some of his YouTube videos and listen to some of the crazy things that he has said. He certainly, one thing we can say for sure, he, from the beginning of his career, has found his inspiration in Russian models, without a doubt. And he has often praised Russian models for his own plans within the judiciary. Well, I know we're almost out of time, and I'm sorry. What happened between 2014 and 2023? Well, you know, members and former members and others who are sympathetic to the open judiciary group, what happened to them? They began to have seats on the Judicial Council. Seats on the Judicial Council, where once they had no voice whatsoever. They were the target of its intimidation. And 2014 to 2023, they have had seats. Now, as Peter has already told us, they are being removed from their seats right now. In the last months, they are being removed from their seats. They've never had control, complete control of the Judicial Council, a majority. However, they have been there. Their voice has been heard. They have been part of the decision-making in the judiciary. Well-meaning governments have adopted various reforms. For example, one person can no longer be Supreme Court president and chair of the Judicial Council at the same time, as Haribin was at one time. Maps were redrawn to try to distribute judicial power more evenly and reduce, maybe not eliminate, but reduce some of the opportunities for nepotism. The Slovak judiciary, especially in some regions, and new procedures for judge selection have increased transparency a great deal. So many good things happened during this period of time when Haribin was pushed down. A journalist, we know, who was investigating at the time corruption in Mr. Fico's government, was murdered. And the crowds in Bratislava were much like the crowds we are seeing in Tbilisi right now, the protest crowds at that time. And the investigation of that murder, which was called the Thrima scandal, revealed the depths of corruption and relationship with organized crime that had been poisoning the Slovak judiciary. And at least positive steps toward investigating this were taking place. Even Robert Fico's personal effort to become chair of the Constitutional Court was resisted during this period of time. I think he tried, again, Peter can nod or shake his head, 2 or 3 times to gain a position as chair of the Constitutional Court. But now we are back to the future, right? We are back. In 2023, Robert Fico returned to power as PM. His government has initiated efforts I don't think I can imagine since communist times to gut anti-corruption investigations and enforcement, gain control of the media, gain control again over the judiciary, and so on, as Peter has described for us. And wonder of tragic wonders, it appears that Stefan Harabin will again have a seat, maybe the chair, I'm not sure, on the Judicial Council, or perhaps become president of the Supreme Court. I'm not sure what direction things are going now. Peter can tell us there. Here comes Harabin again. In 2002, and we thought he was gone in 2013. Here he comes again, and unsurprisingly, it is in a Fico government where Harabin gets reborn. So I want us to think going forward about collaborations and conspiracies between government and the judiciary. Everyone is different. Harabin's was as unique as it could be. He made a deal with himself. He was both the negotiator for the government, for the judiciary, when that collaboration was in 2009. But the mere mention of some agreement between government and judiciary is often considered, has to be considered more deeply to determine if this agreement between government and judiciary is meant to do good or meant to do ill. We need to start looking deeper at these collaborations, I believe. And we need to ask ourselves, what can we learn from the Slovak story, from the Georgian story that we could tell another day, or others? What can we learn so that we can find our ways to improve the judiciaries everywhere in the world, including my own country, that need improving? Thank you very much. Thank you.
Thank you, Jim, first of all, for sharing this insider information, which is very interesting, and it shows its outcomes, positive outcomes, although things are reversing right now, but still, even individual talks on an individual level or on the group level are so important. Okay, it's so much can be said, and questions also come to my mind, but let's give others opportunity to ask questions. If there are several, we will collect and then respond. If not, we can just respond right away. Please, okay, I see Kaja's hand. Okay, go ahead, Kaja, you are the first, as always.
Hello, everyone. I'm sorry, I cannot turn my camera. There's something wrong with my telephone, so I'm just listening from the telephone. Can you hear me?
Yes, we can hear you very well, Kaja. Good to hear you. Good to hear you.
Okay, Jim and Peter, thank you very much for these presentations. I had a lot of questions about Slovakia, but you probably answered half of them. So it was very informative. And I have questions about two particular problems. The first one is as you mentioned, the cooperation between the government and the judiciary. And the second one is the foreign agent law. Let's talk about let me ask you about the first one. The Georgian example is a little bit similar to Slovakia, as you told me, as you just described, but it also has some specific features. And in Georgian example, we had the change of government in 2013. And the new government was threatening judges with criminal prosecution. And the new government wanted to create a commission for miscarriages of justice. And this was a draft law, and I actually participated in a drafting process. This was a commission who was supposed to review all miscarriages of justice and find out the wrongful convictions. Wrongful convictions.
Let me be clear. I want to make,
yes.
Haka, I'm sorry. I want to make sure I understand. It was to find the miscarriages of justice from the prior government, correct?
Exactly.
Okay,
exactly.
okay. I understand now. Okay.
Because the new government was saying that there were thousands of miscarriages of justice for previous government. So they wanted to create a special commission for miscarriages of justice and identify wrongful convictions, and then maybe prosecute guilty judges. So basically everyone was scared, and maybe majority of judges, they were scared. They were scared by the prosecution, by possible prosecution. So they got together and they said, how do we survive? And these Georgian Harabin, which is Chinchaladze and Murusidze, these are Georgian Harabin judges. They told judges that let's get together, let's take over the power again, let's take the power by self-government and start protecting ourselves. So they took the power in 2013, judicial positions in the council. And what happened as a result of negotiation, the Georgian Dream gave away, refused to create the Commission for Miscarriages of Justice, dropped all the criminal prosecutions against judges, also changed the legislation in favor of the judicial self-government, to give more and more power to the judges. For example, the Constitution, according to the Constitution, the power to appoint, to nominate the Supreme Court judges was given to the president. But the Georgian Dream made changes in the Constitution, and the Georgian Dream gave this power to nominate the judges, the Supreme Court judges, to the High Council of Justice. So they changed a lot of legislation to give them more and more power, And as a result of this cooperation, most of the high-profile cases, if not all of the high-profile cases after 2015, they were decided in favor of the Georgian Dream as a result of this cooperation. Now, a Slovakian example. My question was, how did Harabin's government affected how it affected the judicial decision making on the high profile cases? Were they also decided in favor of the government's favor because the Harabin was connected to the government? This is my question. Now the second question is about the foreign agent and the foreign influence. And in Georgia, there's a lot of controversies, and also in Slovakia, and we know about that. But my question is, Slovakia is preparing this law, the draft law about foreign influences. We know about Hungarian example. In Hungary, they had a legislation, quite a similar legislation, which was abolished, which was declined by the European Commission and by the European Court of Justice, which was stricken or stroke, or how do you say that? Which was rejected by the European Court of Justice. So, by introducing this legislation, are you considering the example of Hungary? Because the example of Hungary was much more lenient than the example of Georgia. In Hungary, they don't call it a foreign agent. In Hungary, they did not call them people executing the interest of a foreign power. They just call them the NGOs who have foreign international support. It was quite a neutral name, but still the European Court of Justice decided this was a label, this was a negative label. But in Georgia, now we have a much stricter, much harder case. In Georgia, the NGOs will be the implementing the will of the foreign power. And in Georgia, this is a very negative label. It's a very negative label. You are an NGO and you are implementing the will of the foreign power. And day before yesterday, the Prime Minister, and the Chief, he said, everybody is a traitor.
So this is what he said. I'm saying
once again, he's everybody
serving a foreign
power is a traitor.
Basically, the Georgian dream of traitor. And they were doing. That's
what they're doing. My question is, did you of Hungary? That's my question.
It was there were interruptions with the voice. Did you hear the question? Or
Well,
we should
I think I can somehow.
Okay. Okay, let's collect then. We have Keta and Sopo, and then you can answer. Okay.
And I'll say Peter will be better at answering Kaka's question, I think, mostly.
Okay. Keta.
Okay. Thank you so much, Jim and Peter. It was really very interesting, very comprehensive, and it was really for us very relevant to hear this past and how Slovakia came to this situation when they had some progress in judiciary, and now in one hand new government is here and they are facing such a big problems again. And my question is exactly that when we are trying to get the membership of EU, and we see that Slovakia is the member of European Union. What are the legal mechanisms of European Union which they use to protect the members of their countries not to face such problems as Slovakia has now? Because when we in Georgia are also trying to work on judiciary to get the independence, even we don't have any guarantee that even if we will be the member of EU in one time, so will come another government and they will attack this so big progress and so big work. Can you just share your opinion about this? What is the difference of not being the part of EU and being the part of EU and member of European Union?
Thank you, Keta. We will take Sopo's question, then maybe answer, and then we go to Irakli. Thank you.
Good evening. Thank you, dear Jim and dear Peter. Great to see you this time online. It was very interesting indeed. My question refers to the analytical apparatus or the tools we use in national organizations, local NGOs, media outlets, employ in order to assess the political context or the state of the judiciary in specific political regimes. My impression is that the political processes are much more dynamic than the tools we use in order to really grab these dynamics to analyze and label these dimensions. Today, we talk about the rule of law and backsliding of the rule of law, and I can recall so many international rankings about the rule of law situation in Georgia, which totally misses the real political context and the landscape and the real essence of the rule of law. And I think that this largely happens because of this irrelevance of the tools or analytical apparatus international organizations use in order to assess the political context and the situation in the judiciary in the countries like Georgia, in the countries with non-consolidated democracies. So I think that largely these apparatus and the tools misses new political developments such as populist authoritarianism, for instance, which is visible not only in Georgia, but in Hungary and in so many countries at the same time. So my question would be about the tools or the analytical mechanism. Your position, how can we be more relevant in this process of analyzing and labeling political regimes and the state of the judiciary in specific political regimes? I mean, academia, NGOs, activists, individual researchers, how can we be more relevant and effective in unmasking political regimes? Thank you.
Thank you, Sopo. For now, we have one more question, and maybe we will take Irakli's question and then start answering. Okay, thank you. Irakli?
Yes, hello. Interesting. Thanks for the interesting presentations. We face the reality what we face, but it looks like, it appears that, you know, same thing is happening also in already EU members, in those countries that are already EU members. It looks like to me that there's no effective mechanism. Okay, for example, Jim was talking about this the method of convincing, you know, others, but this might not be as effective as one would wish. Now, judicial arbitrariness. Do you think judicial arbitrariness could be an offense, and whether judges should be prosecuted for so-called judicial arbitrariness?
Thank you, everyone. So maybe we start with Peter.
Peter, why don't we start with Kaka's question, and I'm going to just say that Kaka he is describing a different form of negotiation that took place in Georgia between the government and the judicial powers, right? The government threatened to have these commissions and go after all the judges. And instead of going forward with it, it seems maybe the government traded that away for the long-term cooperation of the judiciary with the government interests going forward, starting in 2013. So it's a different form of negotiation. I only want to suggest about that it's a good thing to study these cooperations, to study these agreements and collaborations, to try to get inside them and understand their motivations. And I think understanding their motivations gives us a better chance to analyze and categorize and combat even those kind of collaborations when they are for bad purposes. So most of the rest, though, Peter, I think you have better answers to.
Sorry, Jim, can I make just one small comment? You also mentioned something about judicial packing, like court packing. You also something about court packing, right? But in Georgia,
Peter did.
In Georgia, we have a judiciary packing, because we have 340 judges, and you can pack 340 loyal judges, so there is no dissenting opinion in the system. And this is almost the reality. We have very few dissenters now in the system, because when you have the elections, almost everybody is voting for one specific candidate. There's no competition inside the system. Everybody's voting for one candidate. So maybe because of a small size of
I hear what you're saying, Kaka. I want to say, though, that
Georgian judiciary,
Georgia is a very small judiciary. But compared
problem
to
is even stronger
Ukraine, compared
because
to
it's a very small
Germany,
size.
compared to Poland, Slovakia is also a very small judiciary. 1,400, something like that, is the number. So it's also a small one. But my question to you back, Kaka, is the vote secret or is it open? Put up your hands. Which is it?
Secret. It's secret.
It is secret. Okay, then you have hope.
Secret.
And at least you have hope. I don't know if you'll ever get there, but you need to persuade some of these judges. I know some good judges in Slovakia. I mean, in Georgia, I know them. I personally know them. You do too. There has to be some hope on that.
Yes.
Peter, you
Yes.
take most of it though. Sorry, I'm saying too much.
No, so I will try to answer the parts of the questions that I could get, that I could hear, because there was some intermission. So, Kaha, you asked about the cooperation of the politicians and the judiciary. And I think in this, it is, well, in this way, I think Georgia is ahead of Slovakia. Described as the situation in 2013 and following years. The same situation happened in Slovakia in 2020. So after the government of Robert Fico #3, his third administration, lost the election because of, as Jim has already mentioned, the case of the murder of the journalist Jan Kuciak and his fiancée Martina Kushnirova in late 2017. The new government came to power in 2020, and they started a big judicial reform that I mentioned. And the part of that has uncovered judicial scandals, from the decoding, decrypting the communication of judges with the people from business and the people from crime. It was uncovered quite a lot of these very controversial networks between what would be possible to say mafia people and some of the judges, especially from the Bratislava courts. I think it was 3 courts were included in Bratislava, the district courts, in all these inappropriate networks. And the new government came in 2020 and started this. They started initiating and asking the Judicial Council for initiating the judicial disciplinary proceedings, and to find the accountability in this. And there was a strong resistance from judges. So it was just the opposite as what happened in Poland. There was the resistance of judges against the Prawo i Sprawiedliwość, against the peace government that was populist and authoritarian according to categorization. In Slovakia, the resistance was against the pro-European, pro-democratic, or internationally perceived pro-democratic, pro-European government. So it was a very bad timing for this government to do that, because as we all remember, in the beginning of 2020, the COVID pandemic started, and the public support disappeared immediately of the new government. Well, they lost all their support because of the measures they had to take. So even the judicial reform was kind of disqualified, not only among judges, but also among the general public, as the political opposition started to play on that note, playing that game that the government is responsible for everything bad, and everything what the government does is bad. So in this way, Georgia's situation is way ahead, probably 5 years ahead of Slovak. And when you ask how did Harabin times influence decisions of the courts, like some of the decisions, of course, like you do not need to influence all decisions, you need only those that matter for the particular group. And this was very difficult and very difficult network, also connected to the small courts, where the court presidents could assign judges to particular cases, even though it was done electronically by random assignation. But imagine you have 4 judges, where only one is focused on particular agenda. Well, there is no choice which judge is going to decide. There is only one. Or if there are 2, well, if one is on vacation at that time, and you know that the file, the lawsuit comes at that moment, you know when is the right time. So influencing the decisions was possible. Also, there were the cases also when the court presidents sent the small papers and written on them the notes, decide like this. It was also uncovered that these things happened. It was also by assignating cases to particular judges. And so these were the ways. And of course, by as Jim already mentioned, by rewarding and by punishing in discipline. So these were the ways that Harabin used in his times. And when you mentioned the second question, the foreign agent law, the Hungarian example, here I did not hear the final part of the question. So I will answer only to what I heard. So if the label is different, well, also in Slovakia, the primary proposal was that it was supposed to be foreign agent, and then they changed it into the organization with the foreign support. But when I think about it further, does it make that much change? It really doesn't. Once you are labeled in some way, it doesn't really, if it is organization with foreign support or whether it is foreign agent, it will, this is basically in all the systems, this is just the beginning. It will lead into probably, in my opinion, it will lead into following lobbying regulation in which you will, or in which the legislator will limit all the labeled organizations from participating in any way. And labeling with different names, foreign agent or organization with foreign support, may do the difference in how likely are people to donate the money for civil society organizations. What is the major income or major source of funding for the civil society organizations? And if people are making the difference between donating to to organization with the foreign support or donating to foreign agent. I think both are very, very discouraging, especially with the condition that the donors will be published. The list of the donors will be published. Then donating to any organization with the label is dangerous for the subject who is donating. So I think all these laws, and they have one thing in common in all these countries, that we can point that there is a bill for the regulation of the foreign support. It is some Russian influence behind the governmental parties. We can see it in Hungary. We can see it in Slovakia now. The international position of Slovakia has changed dramatically since September. Well, this is not a secret. Like, the whole world can see it. So I think that this is something that categorizes that group, that there is a foreign influence, but it comes from the east.
Right.
Okay, other questions?
So Keta's question and part of Irakli's question were sort of, gee, if this is happening in the EU, what's the point? Right. Yeah. That's sort of what I heard. And again, I'll let Peter do most of that. I'll just say a little bit, and that is that there is a value, there is a benefit to being in the EU and having these bad things happen. And that is that at least the EU pushes back, right? I mean, at least there's some body that has some power that pushes back. They got Poland at one point kind of to the brink of, what is it, Peter, Article 14, is it called?
Well, Article 7 is the one
7.
about the punishment.
Sorry. But they pushed Poland almost to the brink of having a vote of expulsion. You know, I don't think that was ever going to happen, but you do have a lot of power, and you have EU money that can be turned down, dialed down to a country, even an EU member, that is misbehaving very, very badly. So there are benefits to it. But I want to say that there is no place on earth where we don't have to keep fighting all the time for our own country and its goodness, right? We can't stop. Doesn't matter. The EU isn't going to completely protect.
Sorry, there was a different question.
Yes. But I'm just going to finish that one small part, and that is, we still have to fight for our own country. We can't expect, you know, the EU is not going to prevent all of this from happening. Sorry.
Well, that wasn't my question. My question, I wanted to know your opinion. So the method of convincing, you know, it won't work, because we were dealing with people who are sophisticated criminals. In Georgian law, we have so-called white-collar crime, and judges can be subject to white-collar, but somehow this article is not being activated. And so judges are public officials like other public officials, and they can be prosecuted for official negligence or misuse of powers and so on. So a judge can be subject to the article that prosecutes misuse of power. What do you think? So-called judicial arbitrariness or misuse of powers by a judge. Let him finish just. And if the judges then say that we are being persecuted, the government will say it's not persecution, it's prosecution. Okay, we were successful to convince somebody or not, and mostly the mafia has retained their levers. So what do you think about prosecuting judges for white-collar crimes as regular public officials, and also for their judicial arbitrariness? Yeah, that's it.
So I want to apologize, Irakli. And please, Georgi, make clear to him that I was only speaking about one part of his question, not the other. I wasn't answering the other part, but I will try now. You know better.
He was answering my question first.
Yeah, I was answering Keta's, but there was a little bit of Irakli's that said something about this is happening in the EU anyway, sort of. So that's all I was doing. So I apologize for misunderstanding. But the crime that you are talking about, punishing a judge for making an arbitrary decision, this is a risky strategy. It's a very risky strategy, because I have seen places where if that crime is regularly used against judges, then the government will prosecute whatever judge it doesn't like, and they can always find a way to do it. So it gives a lot of power to a government to punish even good judges. So it's a risky strategy, I believe. But I will say, punishing judges for being part of organized crime, that should be done. That should be done, right? Not just because they make a wrong decision, But when they actively participate in the activities of organized crime, they should be prosecuted. Peter was referring to the investigation after the murder of a journalist in Slovakia in 2017, I think. And the prosecutors were able to recover the messages of a criminal who had many connections into the judiciary and was able, very able, I think through the help of the state secretary in many examples, right? The person under the MOJ. In many examples, this criminal was able to obtain a verdict on any case that he and his friends needed. This kind of behavior by judges should be prosecuted, must be prosecuted. So I'm afraid, I worry about using the arbitrary judgment law. I prefer using a kind of conspiracy, criminal conspiracy laws against judges. That is what I favor more than the arbitrary judgment law. And again, I apologize for misunderstanding about your question.
Thank you, Peter. Would you like to respond about the EU?
Yeah, I can focus on that. So to Keta, so that's a very good question. So what is the difference? Just very simply and shortly, well, for conditions that the applying country for the EU has to fulfill, and for the conditions and the duties that the member of the EU has to fulfill, is the outcomes are very different. So the applicant country basically is prolonging by not fulfilling or deviating from the reformal process, is basically prolonging the process of entrance, of accession to the union. There are the funds, there are much smaller funds for support than for the member states, but also this can be cut for the applicant country for the accession in case the reforms are not fulfilled or when the duties are already broken. So what happens to the member state? There is a huge variety of the institutions that can be used. For example, institutes that can be used. So there are very soft, like rule of law report that comes out every year. It's like very softly saying like you are not full to particular country, that they are not fulfilling particular requirements that they should meet at that time. But the very much more important are the decisions of the CJEU. But in Polish and Hungarian example, it also appeared that these are not that effective as we would like to have them, to have the real enforceability of the law. So they are even harsher, what is basically cutting funds to the member states. And so there is the program for the support of the member states. For example, Slovakia is still more receiver of the funds than giver. Like we are still receiving more from the EU than we are contributing to the EU. So cutting is very much important question for every government. So right now, the current government is facing some threats of cutting or some information from the European Commission that if the government is going to follow these policies that they are following right now and these changes in the legislation, the funds might be cut. what is especially important that now after the COVID, all the countries are still waiting for every part of the resilience and renewal plan. So these parts of cutting funds is probably the most effective tool. And there is also, at the end of the day, the Article 7, what is like breaking or stopping the water rights of the country in the EU. So these are the tools. Well, if they were so effective, there would be no cases of backsliding. So this is the answer. Like, they are not that effective as they were foreseen to be.
And I want to repeat what I was starting to say earlier, and that is, it doesn't matter where you are. I'm in the United States. I am working every day to try to keep my country doing things the right way. We never get to stop. If you get to be a member of the EU, you don't get to stop. If you get to be in the United States, you don't get to stop. You have to keep working on the kind of things that all of you lovely friends are working for all the time. You just have
I wish that you were here convincing our 84 MPs not to vote tomorrow again.
I don't think I could do it. I don't think I would be any effective.
600 judges.
Irakli is correct. Really... They are members of organized crime, and they are organized. They won't be convinced by me. I understand. I do not believe I can convince the mafia.
We're very much ahead of time now, Ben. I want us to answer to Sopo's question, which is very important, interesting question. And I pretty much agree with everything she said. I also have this feeling that reports and assessments really don't, at least timely, depict the situations in particular countries. What could you say, both of you, maybe, about this?
I think it's really
the members of the academia as well. It's very important.
Thank you, Sofo, for your question. It's great to see you again. So I think you are 100% correct that most of the reports that are done are a matter of checking boxes, right? The reports are so often just, do they have life tenure for judges? Check. Do they have a judicial council? Check. Is a majority of the members of judicial council selected by judges? Check. And you go down the list, right? And these are the things that too often are as deep as some of the reports go, and so they are not really reflective. The only way to truly understand and write a report or have an evaluation or understand what's happening in a country, and it's much, much, much harder work, is to be on the ground, to look at what's actually happening day in and day out in the courts, look at what's actually happening in the parliament, look at what's actually happening, and so forth. So I unfortunately, I don't know a good answer of an easy way to make the reports better, but they have the flaw that you just described, and they very often are, to me, they are just a matter of checking boxes, and we don't learn very much by checking boxes, because in fact, the exact paper that you and Irakli and I are writing is about this, isn't it? I mean, it's about the idea that the reforms are only the reforms, the changes in legislation are only as good as the kind of spirit and goodwill of the people who are working the jobs, who are actually doing the activities. And so I agree with you. I don't know a good answer. Peter may have better.
Yeah, well, I don't know if it is better. I will take it from more general point than Jim did. So far, it's very nice to see you again. So when you said that the recent tools miss the threat of populism, that they do not catch that, and that is true. Like it is really impossible And I think the biggest threat in this is the spread of disinformation in the public space. This usually changes the public opinion very much, gives the support to the populist parties, gives the support to the populist and authoritarian policies that are applied later, and disqualifies the activities of the civil society, disqualifies the importance of the independent judiciary and what is independent judiciary. And so this information chaos that is usually done by, well, the sources, this would be good to have the proper analysis, but yeah, it is probably easy to say that for example, Slovakia is the victim of the disinformation campaigns coming from Russia. So once it will be, there will be a solution to maintain, or at least, yeah, in best way to maintain the level of freedom of speech, and at the same time to solve the problem of disinformation, that might be a good tool against the backsliding. So that might be the beginning. But this is the tool we don't have, and I don't see in following months to have it.
Thank you. I don't see any more hands, and I would love to stop here because we need to also release our interpreter because we are so much ahead of time. I will try to just summarize in really one sentence to squeeze whatever we were talking today about. Such an important list of everything what happens in our two countries. And there's so many similarities, but maybe we should look at the situations in general as whether we have any resistance in the judiciary or we don't have it, and to what extent the resistance exists. They are either openly or especially if there is a hope that there are judges who could potentially be resisting, and then afterwards maybe plan our strategies and tactics. I will stop here. I thank everyone, speakers, participants. Thank you all for very interesting questions. I think this was very fruitful discussion. We're gonna have a discussion paper uploaded on our webpage shortly, so that you have all this information which we were talking about today listed in one document. That is also very helpful, I guess. Thank you again, and good luck everyone with everything you do.
I will be with you in the street. Spirit. Okay.
Thank you so much.
Thank you.
All right.
Bye-bye. Probably in our streets, but
yes, I wish I could be there too, Peter.
Goodbye.
So it was a pleasure and honor. Thank you very much.
Okay.
Thank you.
Bye-bye, everyone.
Bye.